Hello, everyone, and welcome to the Businesswomen Australia Q&A with Meriel Steadman. Today, we're talking about business contracts and the critical issues that you need to know. But before we go into that, just for those of you who are catching this stream live, we are streaming across Facebook, across LinkedIn, and across our YouTube channel. So thank you to all those people that have recently subscribed to YouTube. Businesswomen Australia just for this session. So we're really pleased to have you all tuning in. We're really, really grateful to have Meriel here because she is such a legend in the legal field. She's a partner at Mills Oakley law firm. She's over in Western Australia and she brings to us over 20 years experience in the legal game. She's basically been around the world. She started her career in London. She's worked in Sydney and in the Caribbean. She's had some great stories about that. And of course, in Perth, Western Australia with Mills Oakley, she brings a lot of exposure to different organisations and the different complex disputes that come up. And with her role often in litigation, she's seen everything. So she's worked in the university sector. She's worked for global mining and resources companies. And she is really one of those lawyers that I love listening to because she's very clear, she's very concise, and she's very commercially focused. So very pleased to have Meriel at Businesswomen Australia today online with us in our virtual streaming studio. For those of you who want to contact her, I'm just popping into the chat box. Our website directory at Businesswomen Australia has got Meriel there. You can reach out to her on LinkedIn as well. She's on LinkedIn, and you'll also find her on the Mills Oakley team page. So it's so great to have Meriel here. For those of you who are interested in Businesswomen Australia, we love having women who are working from, doesn't matter what profession, what sector, what state they're in. It's a national collective of women in business, and you'll find all about us on our website at www.businesswomenaustralia.com.au. I'm Lyn Hawkins. I'm the National Director of Businesswomen Australia, and I'd love to welcome you all here. And of course, Meriel, welcome. So I'm going to kick straight into this Q&A because I know your time is very valuable. I'm so glad I don't have to be paying for your time and you're so generously sharing your knowledge with us. Always time well spent with you, Meriel. We had a great boardroom event with you earlier on, or it was in the middle of last year, I think.
Yes, yeah.
Last year, when we were able to meet, and it was gorgeous to catch up with you in person in the gorgeous Mills Oakley law firm, looking out over that amazing view of the Swan River. Thank you very much for hosting Businesswomen there. But we thought after that, there were so many incredible things that you shared that we would run this as a live stream so that women all around Australia can really tap into your expertise and experience. So tell us, to start off with, perhaps, what is the most frequent mistake that you see when reviewing contracts? You're seeing a lot of these contracts, or when a dispute arises over an interpretation of a contract.
Well, thank you, Lyn. First of all, I just want to say how delighted I am to be here today. And, it's always fabulous spending time with you and having a chat. So thank you very much for the opportunity again. So in terms of the biggest mistake that I see, it's definitely inconsistent drafting across a contract. So what you tend to find is during that negotiation phase, whichever party drafts the contract will obviously review it from start to finish before they send it to the counterparty. And you would hope that the counterparty would also review it from start to finish before they send any comments or any questions or any proposals for changes. But if the negotiation goes on and if there's that toing and froing where one party wants to change this clause, the other party wants to change that clause, what you can find is that people assume, well, it's only a change to this clause, so I don't need to review the whole contract again. And that can lead you to having inconsistencies in the contract, which cause problems down the track. because both parties are going to be so entrenched in their view of, well, my interpretation is correct. So what I always advise is get the contract right at the start. Put the time and effort in at the start, spend the money then, because you will be saving yourself time and heartache and significantly more money down the track if you do it right at the beginning. So that's really what I would say. And also, I just want to point out as well, people think about the cost in terms of the dollar figure. And, you know, you always hear the old joke, oh, lawyers are so expensive. But it isn't just about the monetary amount. It's also about the time you are going to spend down the track, not focusing on running your business, but instead on briefing a lawyer, on finding documents, on going to court, on giving evidence. And it's that time cost when you're not running your business that you should also bear in mind. So again, get it right at the start and save yourself time and costs in the future.
It's such good advice. And I think too that the toing and froing between two parties or more to a contract in discussing all those bits within the contract actually really build more collaboration. It's a part of the initial co-creation phase of working together, really. And the amount of assumptions that people make when they go into something really start then being discussed, put on the table, and then clarified, because they can be so often wrong assumptions.
Yeah, exactly.
Yeah. So what checks should we be doing on a party? So, you know, when we're going into a contract with someone, we're always usually very excited about the project that we're working on or the engagement that we're going to be doing. You know, one thing that you really did highlight with those checks and we should be putting in place.
So what I would say is the fundamental step that everybody should be doing is an ASIC current and historical search. And that will give you a number of pieces of information. But the most important things you're going to find out are, first of all, that the contracting party exists in Australia, what its current name is, who its directors and officers are, the fact that it's, well, hopefully, the fact that it's not being wound up, and also where its principal place of business and registered office are. And I'll go through each of those in a bit more detail to explain why they're so important. So first of all, the company existing in Australia and with that current name. So often you can find that when you're contracting, you might be contracting with a company which is part of a group of companies. So make sure that you're contracting with the particular company that you think you're contracting with, and assess, will that company be able to pay if something goes wrong? Because if you think they might not be able to, then you really need to get in place a parent company guarantee or a director guarantee. And even if you've contracted with an organization in the past, you should still do the checks again. And I'll explain from the point of view of a client who hadn't done that check, why it's so important. So a client came to me, they'd got a long-standing relationship with a company that was part of a group. The company existed in Australia, the UK, and the British Virgin Islands, which happily for the client are all jurisdictions in which I am experienced at practicing. What had happened with this particular client was that my client had provided services, and each time they had been paid for those services. But in this particular instance, the counterparty had completed the purchase order, and my client had provided services, but then the counterparty hadn't paid. So I was brought in to advise on how to recover that debt. So the first thing I looked at was, well, let's just check this company exists. And there was actually no company in Australia with that company name. So that was the first issue for the client in terms of trying to enforce in Australia. I then looked at the UK, knowing the fact that this was a group of companies. And there had been a company in the UK with that name, but it had changed its name prior to the date of the latest purchase order. So the only company with that name in existence was the entity in the British Virgin Islands. And having practiced in the British Virgin Islands, I can tell you that you don't want to be trying to enforce against a company over there. And if my client had done those checks in the first place, they could have made sure that they were contracting with an Australian entity where it would have been much easier to enforce in Australia. Now, because I'd practiced in all three jurisdictions, I was able to advise them on the strategy, and we actually got the counterparty to pay because I knew what arguments to put forward to make sure that we had the strongest position possible, and the counterparty effectively capitulated and paid up. And that was lucky though for my client. And obviously my client had spent time and costs to get to that point. Whereas if they'd made sure at the beginning of that particular purchase order that the contracting entity was clarified, then they would have saved themselves time and cost down the track. So that's why that's so crucial. With directors and officers, it's a bit of a sense check, because if you see who the directors and officers are, particularly over here in Perth, Lyn, as you know, we have probably 2 degrees of separation, if that. So directors and officers can have a good reputation or not such a good reputation. So seeing who they are can just assist you in terms of whether this is the type of company you want to be contracting with. And you can also double check, have there been recent changes? Is there anything to give me a red flag that maybe things aren't going as well as they should be doing? Why have the directors and officers changed so suddenly? You know, it just helps you to get a sense for who you're actually dealing with. The next thing is obviously the winding up point. So if the company is in the process of being wound up and you're going to contract with them, then there's a real risk that you will end up having to prove in that winding up process, which can take months or even years in terms of you getting paid for the work that you've done. And it's just an added complication that you want to avoid if you possibly can. And then principal place of business and registered office. It's not that you shouldn't contract with a company based on that, but it's just so that you are fully understanding what you're dealing with. Because if there was a dispute and it went to court, then the counterparty, if they're based in a different state or territory, could argue that the proceedings should take place in their state or territory. And so that's going to add time and complexity and costs in terms of you having to travel to court over there or to deal with a court over there. So it's just those things that you should really bear in mind in terms of the checks to protect yourself at the outset. Again, spend the time up front, avoid the issues down the track.
That's really good advice. And what about doing a basic contract review? You know, when we receive a contract, quite often we get a contract from other parties and it's, you know, coming from them rather than us sort of being in control of that contract. What should we be looking out for?
So this is something that I think a lot of clients fall down on, because they're, as you said earlier, they're so excited about this relationship, you know, oh, got this great deal. And so they don't perhaps review the contract in as much detail as they should to protect themselves. So what I would say on that is you really need to lock yourself away. So no emails, no phone. You need to allow yourself, depending on the length of the contract, but you definitely need to allow yourself an hour or two where you will not be interrupted. And then start at the beginning of the contract and just check the basics. So check the party names, the parties' addresses, and Australian company numbers or Australian business numbers. Make sure those basics are correct. Then move on to the definitions clause. And the definitions clause, this is where I often find issues in contracts, because people will have used a kind of what they like to call a pro forma, but it's not really a pro forma because every contract is different. Every bargain is different. So you do need to be careful about just kind of trying to use something off the shelf. But often I find that there are definitions in the definitions clause of the contract that never appear in the contract. And I also find that while a definition might work in some clauses, it doesn't work in others. So start reading through the contract. And as you read through it, when you come to a defined term, go back to the definitions clause and check, does that work in the context of this clause? And then the other thing is, as you're going through the contract, if there's cross-referencing to other clauses, again, check that the cross-referencing is correct, because that's the other thing that I frequently find with contracts. There'll be a cross-reference to a clause that doesn't exist. And that can lead, obviously, to a dispute in the future about what clause was intended to be referred to in this particular clause. So it's just doing those kinds of checks and being very rigorous with it. You need to be a details person to get it right. And then as you're going through, you'll get to the part of the contract, which is really the guts of what you've agreed. It's the crucial things. So what is being bought and sold? Is it services being provided? What are they? What's the time frame around delivery? What are the payment obligations and the time frame around those payment obligations? And what I've found recently, obviously we're in COVID-19 times, and so I've recently been reviewing a lot of rapid antigen test contracts. And I had a client recently who sent me a contract. They're the purchaser. So they're purchasing from a supplier and they are planning to on-sell to large organizations. So they said to me, oh, we just have a look at the contract. Let us know if there's any issues. Well, straight away, I spotted that under the contract, while it provided for the provision of a branded name of rapid antigen test, it also said that or equivalent. And there were no parameters in the contract as to what would encompass equivalence. So there was nothing, there was no detail at all. And so what that meant for my client was, if they agreed to that, they thought they were getting this brand, they could end up with a completely different brand, which potentially they then couldn't on-sell to their customers because their customers wouldn't agree to it. So they could be stuck with these rapid antigen tests, which were supposedly equivalent, but with no parameters to be able to assess whether they were equivalent or not. So it was a really crucial issue in the contract. Another one that I had recently, again in the rapid antigen test sphere, was a client who had a contract where they were going to introduce customers to the supplier, and my client was going to be paid a commission. And my client said to me, oh, it looks okay to us, just let us know. Again, let us know if there are any issues. And under that contract, the supplier had provided that if the supplier had an increase in costs, including shipping costs, they could reduce the amount of commission paid to my client. Now, there was nothing in the contract about what percentage increase in costs was required or what dollar figure increase in costs was required. There was no requirement that the supplier acted reasonably. There was no requirement that the supplier evidence an increase in its costs. And there was there were no parameters around how much they could reduce the commission fee. So what that meant was, if my client had signed up to that, my client could have found itself being paid a significantly lower commission and having no recourse because they'd signed up to the terms allowing this unilateral right of reducing their commission. So it really, that the core of what your contract is really where you need to be so careful, because that, you know, that you're so excited, but you have to be dispassionate about it and check, is this doing what it's supposed to do? And are there pitfalls and risks for me? Because obviously in those situations that I've talked about, They were significant. They really changed the bargain that had been agreed, and were obviously not acceptable to my client because of the risks. So once you've checked that bit, you then get to the part of the contract which is called boilerplate. And so that means standard terms that you would expect in every single contract. And people often think, well, if it's boilerplate, it doesn't, you know, that's standard. But you still need to make sure that those clauses do what they're supposed to do in the context of your contract. So it's things like jurisdiction and choice of law, dispute resolution clause, termination rights, GST, no waiver, entire agreement. There's just a whole raft of clauses which come in that latter part of the contract, but just make sure that they apply to your contract in the way that you expect them to. And then the final thing is looking at the execution clause, because depending on the type of entities entering into the contract, that will affect how the execution clause should be drafted. And it's actually quite often that the execution clause, again, people have just copied and pasted, not thought about the fact that actually this is a different type of entity to the entity that was entering into another contract. And so they get it wrong. And so that's how I would do a contract review.
I can just imagine how busy litigation lawyers are in the contract space, dealing with and unraveling all these contracts that people have got off the internet and muddled together and borrowed off each other. And, you know, it's like, it's really just listening to those examples is just making me realize just how important it is to get someone with that detailed brain. I'm on the Herman brain dominance thing. I'm apparently very yellow brain, which is very, I'd like to think high level thinking. You know, I make connections. Everything's all very wonderful. It's like, but you need those detailed analytical brains of a lawyer who are used to seeing things too and know what they're looking at to really pick up these kinds of things. So, I mean, you're dealing with contracts all the time, and it's probably not really fair, but can I ask you, what would be your top 3 most important clauses to have in a contract? And I'm sure that this is kind of like, if I had a few litigators here, I'd probably get a different answer from all of you.
I'm sure that you would, Lyn, because their answers would reflect the experience they'd had over the years advising their particular clients. And you know how disputes lawyers like to dispute their and support their position, especially if we all get together at the same time. You know, it can get quite heated, although they always like to think of themselves as, you know, very supportive, etc. So no, I think the first clause that for me is so important is the jurisdiction and choice of law clause. So the choice of law aspect is what law is going to govern your contract. And that's particularly important in Australia because the different states and territories do have different laws. And so a right that you have in one state or territory, you might actually not have in a different state or territory. So it can be a bit tricky in that regard. And then with jurisdiction, what you're looking at is if you decide that litigation or the court is the appropriate method for resolving a dispute ultimately under your contract, then which courts do you want to do that? And again, the courts are different in different states and territories in terms of the procedures, in terms of the timeframes. So it is something that you need to think about to make sure that what you've chosen is appropriate for your contract. Things to consider when you're deciding on choice of law and jurisdiction are going to be where your company is based, where people in the company who might have to give evidence in support of your case are based, where the contracting party is based as well, and also where their assets are based. Because in Australia, you can get judgment in the court of one state, but if the counterparty's assets are in a different state, then you have to go through a process of registering that judgment in the other state. And then usually it's some kind of process. Here in Australia, it's a means inquiry process, which is a court process where details are given of assets and asset value. And so all of that aspect is obviously meaning that it's more costs and it's more time that you're not being paid in respect of the judgment which has been handed down. So it's important to consider. And if your company does have an in-house lawyer or in-house lawyers, then it's worth considering, well, what laws are they qualified to advise on? Because again, it's going to be much cheaper for you if you can use your in-house lawyer for a start. The second most important clause that I would include in a contract is a no waiver clause. And that clause means that it sets out that you can only waive your right if it's in writing and signed by the party waiving its rights. Also, those clauses will often provide that if you fail to exercise your right, or if you only partially exercise it, then that doesn't preclude you from exercising the right in full or exercising it at a later date. And another aspect that you can include is that if you waive your right in relation to one occurrence, that doesn't mean that it's waived in relation to everything in the future. It's only in relation to that one occurrence. And why that clause is so important is because if you don't have that clause in the contract, then it means anything that you say or anything that you write to the counterparty could potentially be taken to be you waiving your rights. And so I had a client who came to me wanting to terminate a contract because the counterparty hadn't been performing. And the contract that they had actually been drafted by a well-known law firm, not my firm, not me, but it didn't have a no waiver clause in it. And the correspondence that my client's contracts manager had engaged in, and he was not legally qualified, but he'd been writing to the counterparty saying things like, oh, we've never insisted on strict compliance with the contract, and we're not seeking to enforce our rights now. There's just a few things we want to work with you to iron out. And so there was all this correspondence where he was effectively waiving the company's right, or there was an argument that he had waived the company's right to insist on strict performance and to therefore terminate for a failure to perform. And so I explained all of that to the client and the fact that there was this risk, and the client was therefore not prepared to actually go ahead and terminate. So that left the client in a position of having a contract on foot with a counterparty that wasn't performing, and there was a real risk that it was actually not capable of performing because of what had happened historically. You know, that there was a question around whether they actually were really the right entity to have entered into the contract, to be honest. The third clause. Oh, sorry, Lyn, did you have a question?
I was just going to say that I think there is this common view that when people put something in writing by email or even text message, then that's actually contractually binding. But you've just made that very clear that if there's that no waiver clause, that the company and the original intention is really the sort of looked after. That's a really important risk management tool when there's other parties sort of, you know, within the organisation at different levels dealing with people.
Yes, exactly. Individuals with no legal background who are trying to keep the relationship going well and inadvertently curtail their company's rights. Yes. Yes.
Yes, we've had comments in our chat room. Is anyone else thinking, OMG, I need to get my contracts checked?
Probably, yes, I would say. So the third clause that I would advise having in a contract is a termination for convenience clause. And I really like this clause. I think, Lyn, I have to say, I mean, it's probably a bit geeky and lawyery, but I think it's my favorite clause. And the reason I say that is because it's just so neat. It's just really, you know, neat, and there's just no issues, and you know, you just do what you need to do. So a termination for convenience clause, it can be a right of both parties, or it can just be a right of one party. But what it means is you don't have to give a reason for terminating the contract. So all you have to do is comply with that clause. And usually the clause will provide that you have to give a period of notice in writing. And during that notice period, the parties need to continue performing the contract. But once that notice period comes to an end, that's it. Contract done, relationship over. And it's just so handy because it's just so clean and neat. There's no arguments around it, except, and this is where you have to be very careful, because believe it or not, Lyn, business people can be very emotional. And so time and again, they'll draft up the termination clause or the termination letter, invoking the termination for convenience clause, but also airing all their grievances that have occurred during this contract. So, you know, but you weren't performing, you weren't doing this, that, and the other. They want to get it all out there because it's really been eating them up. And so I have to basically calm them down. No, because if you start referring to performance issues, then you're creating a situation in which the counterparty can argue, this isn't termination for convenience, this is termination for cause. And invariably, a termination for cause clause will allow the party which isn't performing the opportunity to rectify things and perform. So you're going to end up things being lengthened out significantly, and potentially if they do suddenly start performing, you can't get out of the contract. So what I advise clients is, by all means, go home, rant to your partner, rant to your kids, rant to your dog if you need to, but then sit down and dispassionately draft your termination notice, and don't refer to anything outside of that termination for convenience clause.
I love those three very important clauses. Thanks, Meriel. That's such great advice. Now, what about, I mean, we've talked about the excitement and the passion that goes into establishing new things and new contracts, new deals, new initiatives, new projects. What happens, and what's your view of the old verbal handshake? What happened?
Well, Lyn, believe it or not, a contract doesn't have to be written. It doesn't even have to be verbal. It can be implied by a course of dealing or by a combination of the three. So what I would say is, I personally prefer a written contract, and I will explain why. I actually recently had a client who had a verbal handshake contract, because that's the way he likes to do business. You know, he expects people to do the right thing. And so, you know, they agree and it's all good. And in this particular instance, I would say as well, it was actually, there were terms within the contract that were implied by a course of dealing, because my client performed services and then issued invoices, and they were paid by the counterparty. And there hadn't been any issues. You know, the parties were going along with their relationship perfectly happily. But then when it came to the last provision of services and the last invoice, the counterparty turned around and said, I'm not paying it, sue me. And they just didn't care. Because it was the last one, they knew this was the end of the relationship. They weren't interested in continuing the relationship. And so they just said, I'm not doing it. And so my client then had to think about, well, what do I do about that? Whereas if they had a written contract, it would be much easier for them to enforce their rights. Because when it's a verbal contract, effectively, if you're going to court arguing about the terms of a verbal contract, then it's going to come down to a he said, she said situation. And in a he said, she said situation, the court is going to find that one of you is telling the truth and one of you is not telling the truth. And because court judgments are public, they're there in black and white, you run the risk of the court finding that you are unbelievable, i.e. you are a liar, and that being there written in black and white forevermore, effectively. So it does make things much more difficult in terms of enforcing your rights because of the risks that go with that. So I would say, even if it's mates, even if it's family, it's just better to have something in writing so that you all know where you stand. And particularly if you're going into something which could be long term, memories do fade over time. And if it's small things that you didn't really properly nut out, well, how are you going to deal with those going forward? It's better to have a relationship which is clear and set out in writing than one where you're thinking, oh, I feel like I've been done over here, but it's my friend or it's my family, and and you just end up carrying that with you, and it's just not a good position to be in.
No, I can. I've seen so many disputes that do have happen, over time, and at the beginning it was all well and good, and if there is no written contract in place, it's, you say, if it ends up in the courts, it can be a lot of reputational damage that occurs when everyone starts bringing out each other's dirty laundry, and the media can love it, and it could be eventful reading for people who aren't involved, but it can be really, really heartbreaking. So what records should we be keeping? I mean, what should we be doing to put us in the best position, in case a dispute does occur down the track?
Well, the thing to remember is that if we're talking about a breach of contract claim, then generally you're going to have a 6-year limitation period. So that's something that you need to bear in mind, because obviously the relationship might be going okay, or there might be hiccups in it. But there's quite a considerable amount of time in which a claim can be brought by either you or by the counterparty. So what I would say is, if you have a relationship where you feel like it hasn't really gone as well as it might, and there could be a dispute in the future, that's the point at which you need to be gathering in the records and keeping them for that 6-year period. So you don't need to do it with every contract. If you're comfortable that the relationship is going well and you don't have, I guess, trust your gut on that one. Do you feel that this is going well, or do you feel that there might be some kind of issue? And so the first thing then to think about is your organization's document retention policy, which is a nice way of saying document destruction policy. So how long are you keeping your records for? And that's both hard and soft copy records. And it's important to think about that, because if you do need to suspend your document retention policy in relation to a particular project or a particular contract, then you should be doing that sooner rather than later. The other thing to think about is you can put in place a document hold. So that's where so you identify anybody who's worked on the particular project or the contract, and you basically ask them to collect together all of the documents they have in relation to that particular project or contract, and to send copies to you. So you've got all together what those documents are, and you can you can store them off-site. There's lots of off-site storage companies. It's not like you have to be cluttering up your office with boxes and boxes of documents in case there's a potential dispute in the future, but it's just good to have identified those things. And always check as well if people have taken handwritten notes. So nowadays we all think about electronic, everybody's using computers, everyone's, on their mini device or on their phone, whatever it is. But what I've found is that executives often will still have a handwritten notebook, and they'll put in their preparatory notes for meetings, and they'll also make notes during meetings. And those are the sorts of things which are really important if you do have a dispute that goes on over a period of years or suddenly arises a period of years later. If you're sitting with someone asking them, oh, what happened at that meeting on the 15th of September 2018? You know, I mean, the chances of them being able to remember anything useful without some notes are quite low. So always check if there's something like that you can assist in terms of jogging the memory. Other things to think about are document locations in terms of online. So, for example, periodically companies might change over server. So double check, are you able to get anything off that old server if you need to? And also within the company, is there a practice that people will save things to a P drive or a G drive or some other drive or intranet? Where is it that people are actually saving the documents to, so that you know? And also the same with hard copy documents. I had a case where the in-house counsel went on maternity leave, and the person stepping in thought they had identified within the offices all of the places that documents were, or hard copy documents were. But then I got a call from them the day before the deadline for discovery, and they said to me, Meriel, I've just realized that there's actually a mezzanine level in the office, and I've been up there and there's an entire filing cabinet full of potentially relevant documents. Now, that's not the call that you want to receive the night before a deadline for discovery. But it goes to show, you know, if people are stepping in to cover for a period of time, make sure that someone at the company has briefed them about where everything is kept, and even the layout of the offices, because obviously this mezzanine level, it wasn't obvious. I think it was some kind of back staircase, you know, it was a bit like some kind of science fiction novel in terms of finding this particular mezzanine level. The other thing that I would do is when employees and directors and officers leave the organization, get them to sign a document saying that they have returned all of the company's records to it. And that's really important, because you don't want down the track, you're in the middle of a dispute and suddenly a director's jumping up, or former director's jumping up, waving all these documents at you that you didn't know existed. And if you've got that kind of release form where they've said that they've given everything back to you, that means that in court, the judge is going to see this is someone I can't trust, because they signed to say they'd returned all these documents, and now suddenly here they are with all of these documents. And I had another case where a former managing director, we had written to him by email, by letter, we had rung him and left messages with his PA. The PA told us, I've passed on the messages, he's going to ring you back, and he never did. And then a week out from trial, he popped up saying, oh, I've just discovered a sea container of documents on my property down south. We need to adjourn the trial. And that was a week out from trial. But because we had all of that history, we had all of our letters and emails, we had affidavits setting out the content of the conversations we'd had with the PA. So the court could see that he was not somebody who was trustworthy. And so therefore, they knew that it wasn't fair to my client to actually adjourn the trial on that basis. When you're thinking about documents, also think in terms of evidence more broadly. So who in your organization will give evidence if the matter does go to trial? And this is really a kind of case management strategy point, because it doesn't mean that you shouldn't commence proceedings, but if you know that your key witness is going to fall apart in the witness box, then you need to bear that in mind for your case strategy. So sometimes there are organisations where the only way to bring them to the negotiating table is to commence proceedings. It's as simple as that. Any kind of negotiation back and forth or requests, telling them, you know, that they are wrong legally, it just doesn't do anything. But the minute there's court proceedings on foot against them, and you can search to see which companies have court proceedings or individuals have court proceedings against them, that doesn't look good for them. And especially if they happen to get into the press as well, if the press picks up on it because it's topical, then that's a situation they don't want to be in. So it is sometimes important to commence proceedings in order to reach that settlement. But your case strategy would be, this needs to settle at some point prior to trial, because we know that our key witness or key witnesses just aren't going to be able to stand up under the pressure of cross-examination.
There's so many things in relation to that whole strategy.
Yes. Yeah, absolutely. You know, and I think the thing about that is as well, different lawyers approach it in different ways. And sometimes, you know, a client might really not want to commence proceedings. To them, it is really such a big thing. But so often it's the only thing that is going to get you across the line in terms of getting them to the table. I mean, obviously try all the negotiation, etc. in advance, but if you get to that point where it's just, there's no traction, then litigation, I suppose, for, you know, having done it, having practiced for over 20 years, it's not scary to me, whereas to people who haven't done it, it is scary. But the majority of cases settle, they don't go to trial, and the court is constantly encouraging the parties to try to settle. So, you know, at every stage, they're going to be asking, have you had a mediation? You know, how are the parties going? I remember one case where the very first case management conference, that was the first question the judge asked. And at that point, only a claim had been filed. There wasn't even a defense. So the pleadings hadn't even been closed. And the judge was saying, oh, what are the parties doing about mediation and settlement? I mean, you know, that's how keen the courts are to get you to resolve your issues. So it really isn't a scary thing to commence proceedings, because the courts are hoping that you will resolve it. You know, that's in everybody's interest at the end of the day, particularly if you're hoping that you might have a future business relationship. It's going to be much better if you can.
And in your experience, so then what is the best forum for resolving a dispute? We hear about mediation, arbitration, litigation, or is there something else?
So what I would say is the three you've mentioned, Lyn, litigation, arbitration, and mediation, they're the most common, and they're what people think of most often. And I'll just briefly explain the difference in case some of the watchers aren't sure. So litigation, you're in court, it's decided by a judge, and it's public. Arbitration is private. You have to actually have an arbitration agreement in your contract to go to arbitration. And usually you will provide for there being one arbitrator to make the decision, or a panel of 3 arbitrators. And if it's one arbitrator, you'll usually get an external body to make the decision on who that is. So someone like the Singapore International Arbitration Centre. If it's 3 arbitrators, then usually each party will appoint one arbitrator, and then those 2 together will appoint a 3rd arbitrator who then chairs the tribunal. And the big thing, as I've said, with arbitration, the big difference is the fact it's confidential. And then mediation, that's often a step before litigation or arbitration, or even partway through the process. And that is usually where you have an external mediator who is a private mediator who's trained. If you're in court, then you can do court mediation where you have a registrar taking that role. But sometimes parties will want to have a private mediator. And so usually it will start with the parties being in a room together in a plenary session, and each party will say some things and the mediator will say some things, and then the mediator will split the parties into separate rooms and will go between the rooms, speaking to the parties and trying to reach some kind of consensus. Now, there are other aspects in terms of other dispute resolution mechanisms. So, for example, expert determination is one, and that is where the parties jointly appoint an expert, and usually they will each pay 50-50 in terms of the costs of the expert. But usually an expert is only appointed when it's a technical question. It's not generally a broader, it doesn't generally have a broader use than that. But under a contract, you can decide to have different dispute resolution mechanisms for different types of dispute, but obviously don't make it too complicated. And with a dispute resolution clause, the most common is to have a stepped clause. So what that means is usually the first step will be the parties meet together, and that might be project managers, you know, someone who's kind of involved. They meet together, they're given a specified period of time to try to resolve the dispute. And if they can't do that, the next step would be, for example, the CEO of each organization meeting and trying to resolve the dispute. And they have a period of time to do that. And if they can't do it, then it would be the next step of the contract providing that either party can commence litigation or either party can commence arbitration. Now, the thing about that is, again, you know, a dispute resolution clause, people often think, again, it's kind of boilerplate. It doesn't really matter. But I had a contract where it was a stepped dispute resolution process. And the final step was that either party could commence an capital A action. And that's pretty standard wording. But coming back to what I said at the beginning with the definitions clause, when you looked at the definition of action, it was a definition I would expect to see in a deed of settlement, not in an everyday contract. And so it defined action to be any claim, proceeding, litigation, arbitration, mediation, or other form of dispute resolution, which is incredibly broad and meant that there was real uncertainty about what process would be followed. I mean, obviously it gave the parties flexibility, but it did mean there was no certainty as to what the next step was going to be. So either party could have decided, right, arbitration or litigation, and the other party would have had no say. So it was kind of a who's going to jump first in terms of what best suits them. But it, you know, it wasn't what the parties had intended.
Wow, it's just a minefield of options and a minefield of opportunities for things to go wrong when you hear about things like that. It's absolutely incredible, and we've only got a little bit of time with you to wrap up. And in doing so, Meriel, what would be the best way we can limit our contractual risk exposure?
So this would be my fourth favourite clause if you'd asked me to choose my top four. So having a clause which is excluding liability, limiting liability, and putting a cap on liability. Now, the thing about these types of clause is you do need to be careful as to how you draft them. And you need to think about, if things go wrong under this contract, what are my losses likely to be and how much are they likely to be in dollar figures? So what's the quantum? Because if you're going to allow the counterparty to limit their liability for some of those losses, then that's a really valuable right. And if you don't have a dollar figure on it or a rough dollar figure, it's going to be hard for you to assess whether you should give up that right, whether you should exclude liability for certain things or limit liability for certain things, or have a cap in terms of how much you'll be able to recover. So it is part of the negotiation And the same applies to the counterparty. You know, do you want to limit your exposure to them so that there's a limitation on how much you'll have to pay out if things go wrong from their perspective and they have a claim, they suffer loss and damage? And the reason it's so important to make sure that these are clearly drafted is because usually the clause has different parts to it. And I had a case where the clause, well, the entire contract had been drafted by law firms. Again, not my firm, not me. And in-house lawyers on both sides had reviewed the contract. But when a dispute arose, there was an issue around whether a particular type of claim was excluded or not. And that actually was decided by the court at first instance in my client's favor. But the counterparty then appealed. And so that went to the Court of Appeal. And the delay in terms of the proceeding was from the date the appeal was filed until the date that judgment was handed down, it was an entire year. So that was a year when the main proceeding was just sitting there, nothing was happening, and it was just delay, more time, more costs in terms of this Court of Appeal proceeding. And although my client won and therefore was entitled to its costs, you never recover your legal costs in full. So we're coming back to what I said at the beginning. Inconsistent drafting is the thing that will trip you up every single time. And so having a well-drafted, clear contract is going to be the best way to protect you in terms of your exposure, and checking who you're contracting with is going to be the second thing. So, you know, be careful who you jump into bed with, Lyn.
Well, we won't make a comment on that. I've had a few disastrous business partnerships over my years, and I won't even talk about my personal relationships before I got married. Definitely not when I'm live streaming across Facebook, LinkedIn, and YouTube. But Meriel, what an incredible gift you've just given us in covering so much and practical tips for us to be wary of, to look out for. And of course, I can't highlight enough the importance of having that clearly well-drafted contract where all parties to that contract are very clear and have worked through it together and are all happy to sign off on that contract, to get your lawyers involved at the beginning. It's just been a minefield of examples that Meriel has shared with us. If you're seeing this now and you've just jumped on and it's halfway through, or it's at the end of the stream, please, you can see this recorded Q&A with Meriel Steadman, partners of Mills Oakley, experienced litigation lawyer, amazing 20 years of legal experience to the table today, and all talking about contracts and how to minimize your risk of exposure, how to look after you and your business, and make sure that that everything goes swimmingly in all these exciting times when there's so many opportunities in business. It really is an amazing time. So thank you so much, Meriel. Jump onto our YouTube, subscribe people out there to Business Women Australia. We'll be having more live streams across Facebook, LinkedIn, and our YouTube channel. Our recordings are kept on our website at www.businesswomenaustralia.com.au. Thank you, Meriel.
Thank you, Lyn. It's been a pleasure.
It absolutely has been, and it's goodbye from Lyn Hawkins, National Director of Business Women Australia, and Meriel Steadman, Mills Oakley Law Firm in Western Australia.
Bye. See you again soon.
Absolutely, can't wait.